in order to defend legal cases including 0C297430, the litigant has compiled this very brief presentation to show some of the hard evidence and digital evidence collated for HM and all other courts, judges and or juries. A signed, authored, litigant in person, drafted 25th of June 2021. In brief, if the courts can assess the level of damages owed to the defendant and the defendant's family first, and if the judicial system can obtain these sums, then it will undoubtedly be the court's decision as to whether and what sum is paid to all the creditors' priority and non-priority debts as claimed owed by the defendant by all claimants. The defendant defends that she has no money since she's been prevented from earning her self-employed income as intended. A. The defendant has been incapable of work since January 2020 due to stress, anxiety and depression, reference Dr. Carvel, North Elmham Surgery, and as witnessed by Emma Phillips at North Norfolk District Council Help Hub in January 2020. It should be noted that in this case A was directly caused by B, wherein B. The defendant was prevented from earning her income from 2012 and was completely excluded UK due to the following. She was fraudulently missold a seriously faulty vehicle. The defendant has always needed a reliable vehicle for both personal and for business use for earning her income self-employed, rurally based in Norfolk or elsewhere. Accounts providing all original receipts for self-employed work and expenses have been provided as required and were applicable to North Norfolk District Council from 2006 to current, Breckland Council from the 14th of February 2000 to 2006, HMRC annual accounts for self-employed self-assessment, and bank accounts and online access were actually provided to accountant Adrian Dernley, who very kindly helped provide a pro bono accounts assistance when he was Norfolk County Councillor, as this was for the ARC social enterprise and not-for-profit. C. The case against the supplier that fraudulently provided the faulty vehicle was registered with Norfolk County Council Trading Standards and the Norfolk Citizens Advice Bureau in March 2012. It was of no importance to the County Council that the defendant was prevented from earning her self-employed income, or that the defendant had 3 dependents at the time of the original crime in 2012. According to Norfolk Citizens Advice Bureau, there was no welfare state benefit or any form of financial support for a self-employed person or their dependents in a situation such as this, or a pandemic, or anything else that prevented the self-employed from earning their income. The defendant and the defendant's dependents spent all the family legacy inherited in 2011 on all the equipment needed in order that the defendant could earn her livelihood while travelling across the UK with her dependents and later Europe and elsewhere as planned. In the income tax year 2011 to 12, in round figures, the sum of £39,000 was invested in all the equipment needed for the long-planned and long-worked-for business diversification and as needed to travel and to live in and to earn said income self-employed. However, as the vehicle was seriously faulty, it was only possible for the defendant to earn just £700 gross in 2012. So that was basically £39,000 out and only £700 in, which equated to an income of minus £38,000. And there is no form of governmental support for anyone in the UK in this situation. D. The defendant had no access to any form of credit since 2008, when she was left unpaid for 4 years architectural design work, other than just a basic £500 overdraft facility. All bank accounts were closed in 2008. All creditors' debts were effectively frozen in 2008. The interest was frozen. The defendant paid £1 or £2 per month as agreed through the CCCS and Business Debt Advisory Services not-for-profit organisations. NCAB was also contacted in 2008 and their advice then was to go bankrupt, but as the defendant defended then, she had 2 major projects to work on, either one or both of which could lead to a situation where she could leave the sustainably and thereby be in a position where she may clear debts. And that was after years of hard work as a self-employed architectural designer to get the two sustainable ecological design projects in the first place. The fact that the defendant needed to travel to earn her income was actually one of the two projects that morphed from the 2008 inception. The defendant had worked all hours from 2008 to be ready to launch the ARC in 2012 and working forwards and paying forwards as she did so. This was a family project at the time. Please note that this was one of the two projects originally discussed with the creditors when the accounts were first frozen in 2008. So in 2012 it was all out, there was no money, it was all out. All the accounts were frozen, there was no credit and just a basic building society account with the Norwich and Peterborough Building Society with just a small £500 overdraft, and that was it. The rent was £650 a month, plus all utility bills, plus all business costs, before buying food and all personal costs for a family of four, and all there was coming in while waiting for the County Council trading standards to get the family the refund they were due was just £700 for the entire year, plus working tax credits, housing benefits and council tax relief was assessed by others. There was no governmental support for anyone or a family in this situation. The defendant had advised HMRC what had happened in 2012, then HMRC would have stopped payments for working tax and or child tax credits. If the defendant had advised North Norfolk District Council of a change in circumstances such as cessation of working tax, child tax credits, then North Norfolk District Council would have stopped housing benefit payments and council tax relief. So there was nothing other than carrying on with claiming the basic minimal working tax credit payments. Hence, even though the vehicle was seriously faulty and unsafe, unfit for purpose and fraudulently missold and supplied, there was really no choice but to continue to attempt to cover the shortfall between rent and housing benefits by using the vehicle to take all of the family possessions to the auction houses and the recycling centres, downscale and get into the caravans whilst waiting. They couldn't afford the rent. They also had to cover the colossal unbudgeted expense of trying to cover the cost of running the faulty vehicle whilst moving out of Rosemary Cottage, Rectory Road, Wood Norton, NR20 5BA, while waiting for trading standards, and also waiting for the County Council to recognise the severity of the case and the defendant's family's situation of extreme vulnerability. A family friend offered the defendant and the defendant's family somewhere to park the caravans and lorry and stay while waiting for trading standards to get them the refund as due. As in March 2012, when the case was first registered, County Council trading standards stated that if the supplier was found to have fraudulently missold and or supplied goods that were found to be unfit for purpose or faulty, or that there was sufficient evidence to prove a case against the supplier, then they would take action to get the money back. So it was just a matter of waiting, right? Well, actually, no, it wasn't. It took trading standards until the end of December 2012 to decide that there was sufficient evidence to proceed to take legal action against the supplier, but only then did the County Council actually care what the purpose of the purchase was, and because it was for both personal and business purposes, it said that the defendant must take the case against the supplier herself. And this was because the defendant was registered as self-employed and they stated it was classified as a civil legal case. At that point in time, the defendant, together with her eldest son and her daughter, who was still legally classified as a minor at the time, were without refund or money. Vehicle as purchased and as needed to tow the caravans with. In fact, the defendant was without the use of a vehicle at all for nearly 1 year until October 2013. Address. The landowners stipulated that the defendant and family were not allowed to tell anyone where they were. Heat. Through all the sub-zero temperatures during the winter of discontent 2012 to 13, the family were the heat in this case and survived by huddling together and sharing body heat with one of the pet dogs. Electricity or electric light. There was no way to easily access the internet either. Mains water connection, no easy way to either do laundry or even to bath. It was not possible for the defendant to continue to home study her daughter given these circumstances, even though the County Council also had a record of this requirement, as the application to educate otherwise was approved through the County Council, albeit through a different department. The family was often forced to excrete in carrier bags, And for 1 week in 2013, the defendant and her eldest son were even forced to walk a 2-mile-a-day round trip to collect drinking water from public toilets in the Quaker Friends Meeting House. MB, it should be noted that owing to the uncertain circumstances, because there was no way of knowing how long trading standards would take to get the family the refund needed to purchase an alternative vehicle and proceed with Plan 2, the defendant's second son, Patrick, decided to move in with his father in Cromer and attend Paston College in North Walsham. So the defendant also had to cope with the break-up of the family. This was also later the case when, after Trading Standards' decision left the family without electricity or heat by the end of December 2012, her daughter also had to spend most of her time with one of her friends' families. In order to keep clean and warm, to have clean clothes, hot food, and to re-access education traditionally again via Fakenham High School, which also negated to provide her with any form of support after her horrendous life experience. From the point at which Trading Standards concluded that there was sufficient evidence against the suppliers at the end of December 2012, because the family had only been given 12 weeks, they had overstayed their welcome on the piece of land, and from that point onwards the defendant and her dependents have been under repeated threats of eviction proceedings, homelessness, bailiffs, court action and or legal action and the law, imprisonment, also as the defendant was the victim of crime and without money enough to pay North Norfolk District council taxes after moving into Haddow Court, Hindle Weston, on the 24th of May 2013. The police didn't want to know either. The defendant tried the police at Wells next to Sea, Fakenham and Police HQ at Wyndham all stated that it was a civil case. The ramification of this also meant that victim support could not support the family, as there was no police incident number, although one lady very kindly came out to visit the defendant's daughter to provide her with some support advice, and all due to the defendant's self-employed status. In this situation, the defendant was unable to earn anything at all in 2013 until October. In fact, was forced to turn work away due to her circumstances, as explained to her clients at the time in December 2012 and in February 2013, until they were finally done again, but eventually received a grotty old Peugeot 206 van worth minus £650, as it turned out a few months later, in exchange for the family's 3-ton caravan, which cost them £5,000. Since 2013, the defendant has been forced into repeat dealings with North Norfolk District Council, Housing Benefits and Council Tax Departments and HMRC, as witnessed over several years by both accountant Adrian Dearnley and Norfolk Citizens Advice Bureau, in which case the Citizens Advice, it was primarily Peter Carter Smith, who provided the defendant with advice as litigant in person in her case of appeal against HMRC after they stopped child tax credits when she explained the situation later in 2014. The family only had furniture and white goods from November 2013 thanks to friends' donations, and especially North Norfolk Roofing, who purchased a house clearance for the family. The litigant was forced to work unpaid minus all expenses on all legal cases, themselves stemming from the original case, and her family's needs of support since the 2011-12 crime against them by RPI International Limited. In the legal case against RPI and in appeal against HMRC, with other legal cases including those from Vodafone and 3G, and now currently with more legal cases being raised by yet more creditors, and for which reasons this presentation has also been prepared to show some of the evidence collated and kept in defence. Brief statement from the defendant. I'd have been far better off as a convicted criminal. I'd have had central heating, heat, electric light, showers, clean clothes, easy access to the internet and a fixed address, access to education, hot food and access to doctors, dentists, as well as defence barristers, lawyers and or solicitors, as would my children. As victims, neither my daughter or my eldest son or I had any way to easily access any of the aforesaid luxuries or human rights, and that is criminal. I can't go on like this. It's completely untenable, and in any event, even as litigant in person, writing as defendant, plaintiff, claimant and or appellant, I could never be my own damages assessor. It was always a case for the courts.